Well, by now, most doctors and hospitals and pharmacies have heard about Texas prompt pay, but they don't understand or they don't know the history of it. I served in the Texas legislature from 1991 to 2003. In the late 1990s, doctors and hospitals around the states came to the legislature and complained about practices of big insurance companies. It was a practice that they called delay and deny. The big insurers were delaying payment and denying payment for up to over 180 days in some cases. This was causing a terrific cash flow problems. The hospitals testified that they were cutting services. Doctors testified that there were services they couldn't perform because they simply couldn't pay for them with the schedule that the insurance companies were making. In response to that, the legislature ultimately acted the Texas Prompt Pay Act. It makes for a more efficient healthcare system for Texas. It benefits the patients of Texas, and it benefits the healthcare provider, the doctors and the hospitals and the pharmacies. It's an important act, and it's an important policy for our state, and it's one that we need to pursue in order to have a more efficient system. Now, if you couple the cash flow issue with the difference in the value of services contracted in the network between the value of the service for the doctor and the hospital and the pharmacy and what they're actually paid under the contract, you overlay the cash flow problem on top of that, you can begin to see why our medical profession was having difficulty with this issue. It is an abusive practice by big insurance. It was one that had to be stopped, and that's the purpose of the act. And that's the reason why doctors and hospitals and pharmacies, who are not generally litigious by nature, need to pursue their rights underneath this act. It's good for all of us in Texas. I can give you a quick example that if you purchase a piece of equipment in your doctor's office or a hospital purchases a piece of equipment, there's a cash flow necessary to pay for that piece of equipment. If the insurance companies are slow paying, it generates a difficulty for both healthcare providers. And so the ultimate decision is made: do I hold off on purchasing the equipment? Do I not have the equipment available to treat the patients? Is there delay in treatment for the patient? Are there certain services they couldn't contract for? It is pervasive throughout the system. Now, insurance companies should have to live by the rules just like the rest of us. If you and I don't pay our bills on time, we get penalized. And that's all we're asking them to do, is pay your bills on time. These are clean claims. They are not claims that are objected to in any form. They're simply being held over time by an insurance company and not paying correctly. That's an abuse that had to be stopped. Now, if we do this as a group, if the state of Texas healthcare providers will stand up as a group, the insurance companies will stop this practice. They will stop this practice, and it will benefit all of us. It's a benefit to your practice, and it's a benefit to your hospital, but it's also a benefit to all of us as Texans and as patients. We frequently are asked or are told, well, we already have a collections department, and they take care of this. The truth is, they're not set up to do this. The software is not set up to do this. This is a retrospective look of 4 years at late payments by insurance companies. The software simply is not designed to do that. So what has happened over the last several years is, as the technology within the medical profession has improved in the billing, we've also developed technology in our software to go back and scrub those claims, look at the dates of submission, the dates of payment, and determine which ones were late, which ones were clean claims not objected to. And that's what sets up the damage model under the Prompt Pay Act. Your collections department is not designed to do that. The collection software is not designed to do that. And frankly, modifying it to do so is incredibly expensive. And so it's an interesting niche that the computer folks that have spent time over the last several years developing this issue have found, and it's a good service for us. But it is unique to people that are able to do the prompt pay model, damage model. Okay. This process involves preparation of a damage model, which is mining the data that exists within your electronic filing system using specialized software that has been developed to do so. But it also involves a legal proceeding of arbitration, so you're going to require a lawyer. And I know that that's not necessarily something that doctors and hospitals and pharmacies like to do, but the fact is, to pursue your rights under the Prompt Pay Act, you need to hire a lawyer, and you need to have that damage report done for you. and then an arbitration will be filed. It is not a process that is very intrusive to your practice. In fact, we have designated it into tasks to take 2 or 3 employees a couple of hours each, and we can mine the data necessary to prepare a damage report. Currently, there are no depositions being required. There's not even a requirement that the doctor be present at the arbitration. And so it is minimally intrusive. But it is very important that we pursue, as I described earlier, because it is the only way we'll fix the system and make it more efficient. I began practicing law in 1979 after graduating Baylor Law School. I was fortunate enough to work with some very good lawyers, and I became involved with complex litigation at a very early age. At age 28, I did the appellate work for the first personal injury class action in the history of our country involving asbestos litigation. I've been involved in complex litigation involving multiple parties for 30 years. I've been doing this a while. It is not an easy process. It does require complexities in the law, but it is a process that can be done within generally a year and a half to 2 years. Honestly, it is a process that requires someone with understanding of complex litigation and is used to negotiating sums of money that are involved here. So I'm not going to tell you that I'm the only lawyer in the state that can do it. I would never do that, but it is important to look for qualified people that can handle these claims. Obviously, the ability to handle litigation and complex litigation is key, but I also have the background of legislative activity from 1991 to 2003. I understand this act. I understand why it was put in place. I understand the purpose of it. I know the individuals that authored the bill, passed the bill. I was there and voted on the very first one. I heard the debate. I listened to the testimony. This is not a new process for me. I understand it. I know it. And we need to do together. Frankly, it's for the good of all of us. If you are a doctor or in a practicing group or in a hospital or pharmacy and you want to find out more about this, the first thing you need to do is pick up the phone and call me. We can visit with you personally for free. We'll set out exactly what steps are required. What makes us unique is that we're going to give you the first damage report. You're going to see it first and make a decision at that point in time whether or not you want to continue and go forward with this process. You will have to enter into a contract and have HIPAA requirements met so that we can mine the data. But we're going to give you the first damage report for you to look at, and at our cost. I'm that confident that we're going to find the abuse by the insurance companies in your practice. But if at that point you decide you don't want any part of this and don't want to go forward, then you walk away and so do we. But I believe you'll want to pursue this because I think you'll understand the need. I think you'll understand that this is a worthwhile policy. And I think you'll understand why it's important for you.